Welcome to this comprehensive guide on the top 5 exam mistakes to avoid when studying the Indian Contract Act of 1872. As an LLB student, mastering contract law is essential for your legal career. This presentation will help you to identify and overcome the most common pitfalls that students make during their exams. Let's begin our journey to better contract law understanding and exam performance. Our first major mistake to avoid is what we call definition without application. Many students fall into the trap of memorizing definitions without understanding how to apply them to specific legal problems. The error occurs when you can recite the definitions of a legal concept but fail to connect it with the facts presented in the exam questions. The solution is always bridge theory and facts. When you define a legal term, immediately show how it applies to the specific scenario in the question. Why does it matter? Because examiners aren't testing your memory, they are testing your ability to apply legal principles. Students who demonstrate applications skills consistently score higher than those who merely recite definitions. Mistake numbers 2 is what we call the anchor of law, ignoring sections number from Indian Contract Act. Section precision is crucial. Failing to recite the exact numbers show a lack of detailed knowledge. When you mention section 2A for proposal, instead of just saying the definition of proposal, you should demonstrate authoritative knowledge. Remember, sections are the framework of this entire act. They should serve as the cornerstone of every legal argument you make. Think of it this way: a doctor wouldn't diagnose without referring to a specific medical classifications. A lawyer shouldn't argue without citing specific legal prohibitions. Make section numbers your friends in your contract law exams. Our third mistake to avoid is what we call the precedence principle, failing to support your answers with case laws. Treating legal principles as mere theoretical statements instead of the rules established by the precedents is a critical error. The solution is always support principles with the relevant landmark cases. For example, when discussing offer and acceptance, referring cases like Carlyle versus Scarborough Smokeball Corporation demonstrates the deeper understanding. Remember that the cases laws are indispensable. Proof in legal argument. Use cases names to support your points, not detailed cases facts unless specifically asked. Examiners want to see what you understand, how judicial precedents shape the application of the contract law. Mistake number 4 is confusing void agreements with voidable contracts, a distinction that's fundamental to contract law. A void agreement is one that is not enforceable by law from the beginning. It lacks essential legal elements. For example, agreements in restraint of trade are typically void. Void agreement is one of that is not enforceable by law from beginning. It lacks essential legal terms. For example, agreement in restraint of trade are typically void. A voidable contract, on the other hand, is contract that is valid and enforceable but may be set aside at the option of one or more parties. For instance, contracts entered into under coherence are or undue influence are voidable. Understanding the precise movement when a contract becomes void versus voidable is crucial because it determines the available remedies. Void agreements cannot be enforced while voidable contracts remain valid until set aside by the aggregated party. The distinction often carries significant marks in exams, so ensure that you can clearly differentiate between this concept. Our fifth mistake is poor answer structure. Many students with a long unstructured para that make it difficult for examiners to follow their reasoning. The solution is to use IRAC framework: issue, rule, application, and conclusion. First, identify the legal issue in the question. What specific legal problems need to be resolved? Second, state the relevant rules or law. This includes definitions, section numbers, and case laws we discussed earlier. Third, apply the rule to the facts of the case. This is the most crucial step where you demonstrate your analytical skills connecting legal principles to the specific scenario. Finally, provide a clear conclusion based on your applications. Your conclusion should logically flow from your analysis. Using IRAC ensures your answers in the systematic, comprehensive, and easy to flow exactly what examiners are looking for. To help you succeed, here's your exam success checklist. First, practice deep reading. Read each question twice to identify both the facts and the specific legal issues. Second, always think section first. Before answering, identify which sections of the Indian Contract Act are relevant to the question. Third, master time management. Allocate your time based on the weightage of each question and always structure your answer using IRAC. Fourth, harness precedent power. Support your every legal principle with at least one relevant case laws. Remember the word at the bottom of the slide. Law is not just about knowing the rules, it's about how you argue them. This is the essence of the legal examination success. Thank you for your attention to the guide on avoiding common mistakes in Indian contract law examinations. Your dedication to mastering these strategies will undoubtedly pay off in your exams. Apply this technique consistently in your practice sessions and exam preparations. If you found this helpful, please share it with your classmates who might benefit as well. And do like, share, and subscribe. Thank you for watching.